We are live.
All right.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Massachusetts Appeals Court oral argument session. Our first case is number 2019 P863, Anthony Berry versus Department of Correction and others. My name is Justice Peter Sachs, and I'll ask the other members of our panel to introduce themselves so you can recognize their voices.
Good morning, Dalila Wendlandt.
Good morning, everybody. I'm Edward J. McDonough, Jr.
And Mr. Berry, can you please...
Welcome to the Massachusetts Appeals Court oral argument.
Excuse me, Your Honor. May
yes,
I say something?
Yes,
May I say something?
Mr. Berry, why don't you go ahead and just, can you hear us all right?
I can hear you, but may I say something to you real quick?
Sure.
I think you mentioned something about Anthony Berry.
Yes.
My name is Jermaine Berry.
Jermaine Berry.
Yes, my name is not Barry. It's Jermaine Berry, Jermaine, and my last name is Berry, Berry.
Okay, so
I think you have the wrong person.
It seems like. Let's.
All right, we are live and recording.
Good morning and welcome to the Massachusetts Appeals Court oral argument session. Our next case is 2019 P242, John Dutcher versus Louise Spencer and others. My name is Justice Peter Sachs, and I'll ask our other justices to introduce themselves so you can recognize the voices.
Good morning, this is Judge Wendlandt.
Good morning. This is Judge McDonough.
And Mr. Dutcher, for the record, can you just state your name so we can have you?
Yes, sir. For the record, my name is John Dutcher.
All right. And Mr. Guberman?
David A. Guberman for the appellees.
All right. So as you know, this argument is being held on Zoom and live streamed to the Appeals Court's YouTube page. Anything said will be heard by all of those observing and become part of the record, just as in a physical courtroom. Please speak slowly, clearly, and one at a time. You'll be on mute till it's time for you to argue. Each side will have 15 minutes, during which we'll ask questions. For phone arguments, I'm going to try to remind you when you have a minute and a half left, so that you'll know that it's time to start winding up. We've read your briefs and the record, and we know the facts, so please jump right into your argument. And with that, I will ask Mr. Dutcher to begin.
Thank you, Your Honor. Thank you, Your Honors. First, I didn't get notice of this until 2 days ago, and I didn't have any access to the law library, so please bear with me. I'll do the best I can. The first thing I want to address is I believe that the judge's entire ruling is erroneous, as it is based upon procedural error. I filed this case under the declaratory judgment statute. I made that clear in the very first line of my case. However, during the hearing, I've got my records here. During the hearing, the district attorney insisted that this was a case governed by the Administrative Appeals Act. And give me a minute now. I'm just nervous, that's all.
No problem. Take your time.
In the record appendix, at number 115, at 15, it clearly says that, again, I'd like to reiterate at that time in the previous hearing that I filed a motion under General Law, Chapter 231A. A significant difference between the two statutes is that if it's an administrative appeal, deference has to be given to the Commonwealth. They file a copy of the record. Of course, the court knows this, but the burden then becomes on me. under the Declaratory Judgment Act, it's not, the burden isn't on me. It's that I state a case and that I'm requesting the court to declare my rights and my duties under the situation.
So, Mr. Dutcher, we understand the point you're making about the difference between seeking review of the administrative decision and bringing a declaratory judgment action. But once the defendants brought their motion for judgment on the pleadings, it seems as if the judge could view that as essentially a motion to dismiss your declaratory judgment action on the ground that it didn't state a claim, even if all the facts that you alleged were true. So viewing the DOC's motion that way and viewing the judge's decision that way, what legal errors do you say that he made in dismissing your declaratory judgment action?
I don't think that he dismissed the declaratory judgment action. I think that they just, if you read the transcript, I had a hearing, and they insisted that I was that the declaratory judgment, as we all know, a declaratory judgment can be enjoined with a motion for administrative appeal, but the administrative appeal is the governing body. However, as I stated in the case, you can't challenge a state statute as applied in an administrative appeal, which is part of the case. So that clearly indicated that this was not an administrative appeal. So the reason I feel that the judge couldn't dismiss the declaratory judgment is because the statute, the language in the statute itself. And
Mr. Dutcher,
as opposed to Standing Order 196 in the declaratory judgment, which I'm sure you're aware of, is that I'm asking the court to declare my right. And the reason I did that is...
Can I interrupt you for a second? This is Judge Wendlandt.
Yes, ma'am.
What is the declaration that you seek?
Real simple. I was committed to the treatment center, as you know, and then I was cleared in 2011. The DOC and every agency insists that I have not completed the sex offender treatment program. And they insist, let me grab something here, they insist that being cleared, not SDP, doesn't mean that you're still don't pose a risk. In fact, their exact words are that they believe that the judge tells the jury that when they go to make a deliberation to decide whether you're still a threat, that they don't have to say that you're such a threat as that you need confinement, but you can still be a little bit of a threat and be released. That's absolutely absurd. But yet, if you look in the trial hearing, that's exactly what the DA said, and it's exactly what the judge says later on, that I haven't completed the sex offender treatment program. However, I'm going to just have to wing it. I'm probably better at it. The Department of Corrections went to court and told the federal judge that the treatment program was going to be the same program for the civilly committed inmates and for state prison inmates who they brought down there to do the treatment program with. However, I made it clear in my thing anyway. The significant difference is that when the state inmate completes treatment, he gets a note in his prison file. A civil can never get that. I'm an inmate still. I'm serving a prison sentence. That while there, I'm still under an inmate. I never could get a certificate of completion because obviously they don't want me to run into court and say, they said I've completed treatment, so I shouldn't be SDP. That court, by legislative intent, that decision was left by legislative intent up to a court of law to determine if I've completed treatment and no longer pose a risk to the public. They insist that now that that has happened, they insist that I haven't, and they insist on saying that I have to go back down to the treatment center and do the treatment program again, barring no catalytic event to have that happen. I have been here for 9 years. I don't have a single solitary ticket or case that would involve them sending me down there for that. Also, the DOC themselves have classed me as a low risk and a low to reoffend and a low risk for violence. And therefore, I meet the penological goals of the program itself. The problem with not being able to receive a thing and having them wanting to send me down there is it will invoke a double jeopardy, a Fifth Amendment claim, because no matter who, you walk in the door down there, I could have done 22 years of treatment like I did, but when I walk in that door, it's as if I got convicted yesterday. And they evaluate me under a static 99 evaluation. And by the end of that, because of the crimes in the past, I will be considered a high risk. That alone gives the district attorney at the end of my prison sentence now probable cause to say to a judge, we want to recommit Mr. Dutcher, as like they did in Chapman. The difference between me and Chapman is that Chapman was cleared under the law when it allowed a person to still be sexually dangerous, but he had it under control. A judge had his discretion to release him. Chapman was ordered to do treatment. The law changed in 1999, in which I was cleared in 2011, that you could no longer be released with a mental abnormality or personality disorder. Those are not just something that could be dismissed by the court. Those are legitimate, factual arguments and claims that should be resolved, or else anybody, a handful of us who had a prison sentence at the time and was civilly committed at the time, are going to be forced to continuously repeat a program and not be treated the same as the state inmates who have been completed the program. They don't make them do the program over and over again, and then they don't sanction them for not doing the program over again. I've been sanctioned for 6 years now because of this situation, and I can't let myself go down there and be evaluated so they could say, hey, guess what, 2009 and 2020, he's been found to be a high risk to reoffend, Your Honor.
Mr. Dutcher?
Yes, sir.
I think the defendants in their brief point to some evidence in the record that although you were found not to be an SDP by the jury, there were some aspects of the treatment program that you did not complete.
That's their assumption, but that would be ludicrous because I would never have been cleared. So the jury heard all that. The jury heard all that argument at the Section 9 trial in 2011. They presented all that evidence to a jury. A jury disagreed. I enclosed that in the jury's decision, and in there, the judge wrote that the evidence was presented, testimony was heard, and the jury ruled that Mr. Dutcher is no longer sexually dangerous.
But they could make that.
They can say that, but that's not true. I've completed the program. In fact, treatment for a civil is 3 times more than it is for a state inmate. The average treatment for a civil is 15 years worth of treatment, as opposed to maximum 3 years for a state inmate in their program. And the program, according to the DOC in the Healy case, is the exact same program. So I could not have been cleared by a jury if they didn't feel that I have completed treatment. A jury's decision has to be upheld. And that jury was charged with 2 things: to find out if I have completed treatment, and therefore, if I've completed treatment, do I no longer pose a risk to the public safety? for the life of me, I don't understand why I can't get clarity from the court. Isn't that what the declaratory judgment statute is about? Is to declare my right? Did I or did I not complete treatment when the jury cleared me after a trial?
So to make sure we understand your argument, you're saying that because you were found not SDP by the jury, then the district attorney could not bring another petition to have you found SDP?
Unless I act out, that's absolutely right. And all you have to do is look at the Chapman decision to realize that the only reason that court ruled in a 4-3 decision that he could be looked at was Chapman was, as a condition of his release, required to do sex offender treatment. And he failed to do that. And that was, and so he was suffered from a mental abnormality called pedophilia, and he was required to do treatment, and he didn't. And the court said it itself. We didn't look at his past crimes, so that's not the issue. The issue is his current state of mind now because he didn't continue on in treatment.
Okay.
Unlike Chapman, when I was cleared, there's no caveat in me being cleared that says, Mr. Dutcher, you shall continue in treatment, and you shall. That's not the case. The jury has to decide whether I have a mental abnormality or a personality disorder.
So, in essence,
said no.
Just to make sure we understand, you're seeking a ruling that the DA could not bring another petition unless something changes in your situation while you're incarcerated, and therefore that the DOC could not use the Code C override to deny you a level 3 or lower security classification.
I'll be honest with you, Your Honor. Right now, I don't care. I could care less about the Code C. My life is in danger because of the pandemic, my age, and my medical condition. My concern is more about that that I would like the court to rule that I have completed treatment. And yes, that barring any catalytic, if that is even a word, event, they cannot. Right now, we're talking about today, not presupposing the future, but today. Absolutely, if I act out, they have a right to see me. But as we have this hearing today, in the present, there is nothing that allows the DA to seek petition against me. And,
Mr. Dutcher?
And the reason I'm seeking that ruling is because that's what the parole board consistently uses to deny me parole.
Mr. Dutcher?
Times. I see him tomorrow for the 23rd time.
Just
and
need
my
to tell
argument is that's exactly right. Unless I did something, then they have nothing. And the only and before they can get probable cause, there has to be a sex offense to base the probable cause on.
Mr. Dutcher?
There has to be some type of action within the law itself that a person
Dutcher?
had. Yes, sir.
Just need to tell you, your time has expired. We'll give you another 30 seconds just to make any final points that you want.
Yeah, my two main things, Your Honor, to be honest with you, is that I have completed treatment. And that I should have a notation the same as the other state inmates got in their file. I should have the same, be treated the same, and should have one in a notation in my file. And the second thing is that's right, is that the court declared that I no longer pose a threat to public safety. They didn't know I was coming back to prison. They thought I was being released to the public, as according to the law. And number two is that that's right. Unless there's something that I act out between now and then, there is no justification for me being able to be seen under the law. I'll be honest with you. I thought my brief spelled out my case pretty precisely.
Well,
and clearly made the difference between me and Chapman and the other things that the district attorney ruled on. But again, my case should have been heard under a declaratory judgment, and if nothing else, I should be sent back to court to have a hearing held under the declaratory judgment.
Yeah.
Gotcha.
All right. We'll have to leave it there, Mr. Dutcher. Mr. Guberman.
May it please the court. Although I'm happy to answer any questions any of you may have, there were only 2 points that arose during Mr. Dutcher's oral argument that I'd like to address, and they are sections 9 and section 12 of chapter 123A. With regard to section 9, which was the basis for the 2011 decision that he was not then a sexually dangerous person, the only thing that was adjudicated was that the Commonwealth had failed to prove that he was an SDP beyond a reasonable doubt. There was no adjudication one way or the other as to whether he had completed treatment, whether he was or was not a risk to society. It's merely that the Commonwealth had failed to carry its high burden of proof beyond a reasonable doubt. That then joins in with Bruno Chapman and the standard under section 12. Chapman really controls this case with regard to the applicability of section 12, and it means that as long as, if there's a future decision to seek civil commitment, as long as the district attorney is not trying to relitigate the 2011 decision, is not trying to argue that that was wrongly decided, but instead is making an argument that under the circumstances and under whatever expert opinion is offered in that future proceeding, that at that time Mr. Dutcher should be found to be an SDP, then Chapman allows such a proceeding to go forward, and it allows for a decision. It doesn't require, but it allows a decision to be made that he indeed is an SDP based on his refusal, as is his right, to participate in the sex offender treatment program. So if the court were to reach the declaratory judgment question on the merits, and we've presented argument why it's not jurisdictionally before the court, but if it were reached on the merits, the judgment below should be affirmed because the law permits in the future a Section 12 action to be brought notwithstanding the 2011 adjudication. So with that having been said, I'm open to any questions the court may have, and otherwise I'll rest on my brief.
This is Judge Wendlandt. I guess my only question is, I understand Mr. Dutcher's argument is that he's actually already completed the sex offender treatment program as part of his original SDP commitment. Is that, can you shed some clarity on that?
I believe so, Your Honor. First, he doesn't really argue, I believe, that he's completed it. He says in his brief that he should be deemed to have completed it by reason of the Section 9 decision in 2011. And as I've just tried to explain, that's not what was adjudicated. Beyond that, he has put into the case as exhibits to his complaint, and therefore they're properly looked at in evaluating whether or not he has stated a claim, if we get that far. He's put in certificates from his period at the treatment center, and they show in at least 2 instances that the end of course evaluation was he had not passed or he had an incomplete. So as a factual matter, those certificates plus the letter that's in the administrative record from Christopher Mitchell, which says that based on a review of his records at the time of the, or shortly before the Section 9 hearing, that he had not completed the treatment program there, shows that as a factual matter, he is mistaken. He really only has a legal argument. But even if he had completed the program then, that's not a finder or an adjudication that there's been a cure, if a cure is possible. It's perfectly open for the district attorney, if there's qualified expert opinion in the future to this effect, to say that even if as a result of treatment he had his impulses and mental abnormality under control in 2011, or at least the Commonwealth failed to prove beyond a reasonable doubt that he didn't, that as of some future date, that's no longer the case, and he is an SDP.
Mr. Gurman, this is Justice Sachs. I've seen a lot of references in the papers to Code C. I see the DOC's regulations, or at least policies 103 DOC 446, that seem to embody some of the rules that are in Code C, but I don't see a document that says here are the codes and here's what Code C is. Is there such a document in the record anywhere?
I will review it, Your Honor, and if there is, I'll send you a letter. But my best recollection is that it was explained during argument before Judge Tucker, and there's no disagreement between the parties that the Code C override has the effect of requiring that anyone with a Code C override may not be classified below medium security. I don't think that there's a dispute about that.
All right. Further questions from the panel?
No.
All right. Thank you very much, both of you, for your arguments, and please stay safe.
Your Honor,
Yes, Mr. Dutcher.
could I just clarify two things because I didn't have a lot of time, and I promise I'll make it real quick.
Mr.
Because I
Dutcher,
know the rule can give me 5 extra minutes if the court would let me.
we've got to get on to our other arguments this morning. If you have a new point to be made that the department raised for the first time this morning, you can put it in a letter to the court. But we don't allow rebuttal arguments in the appeals court. I'm sorry. All right, so we'll have to leave it there. Thank you both for your arguments.
Thank you, Your Honors.
All right, we are live and on the record.
All right, good morning and welcome to the Massachusetts Appeals Court oral argument session. Our next case is number 2019 P143, RAMON OLAN versus Robert F. Murphy and others. My name is Justice Peter Sachs, and I'll ask the other members of our panel to introduce themselves.
Good morning, Judge Wendlandt here.
Good morning, everybody. My name is Judge McDonough.
Mr. Olan, could you identify yourself for the record, please?
My name is Ramon Olan, O-L-A-N, and I'm the plaintiff in this matter.
All right, and Ms. Sawyer, can you identify yourself and the parties that you represent?
Thank you, Your Honor. Caroline Sawyer for the Commonwealth, Bridgewater State Hospital, Robert Murphy, and 7 unnamed defendants, Pamela McEachran, Steve Kennedy, and Dan Callis.
Okay, thank you. As you both know, this argument is being held on Zoom and live streamed to the Appeals Court's YouTube page. Anything said will be heard by all of those observing and become part of the record, just as in a physical courtroom. A pseudonym must be used for any person's name that's impounded. Please speak slowly, clearly, and one at a time. You'll be on mute until it's time for you to argue. Each side will have 15 minutes to argue, during which we'll ask questions. I will try to let you know, because you can't see a clock, that when you have 90 seconds remaining, 1.5 minutes remaining on your argument. We've read your briefs, we've read the record, we know the facts, so please jump right into your argument. And with that, Mr. Olan, I'll ask you to begin.
I would like to give thanks to the Honorable Court for continuing to allow this process given these difficult times. Respect to the court, I would like to state that I would I want to rely entirely on the brief that I filed. I also want to point out that I am grossly prejudiced by not postponing the oral argument because for the last 7.5 weeks, I have been locked in a cell for 23 hours a day and only come out for 1 hour for a shower or a phone call. I do not have any of my filings with me and have no access to the law library due to the COVID-19. However, with the court's permission, I would like to shine some light on some important facts in this matter. The defendants had no discretion to commingle me with my attacker. Nowhere in any of the statutes does it say that they can commingle. The only thing that they say that they can do is for when a prisoner is doing time to get committed under General Law, Chapter 123, Section A. So because the legislature indicated that this is when someone can be committed, it means that no one else was intended to be committed at Bridgewater. That is saying that the cadre should never have been in place in the first place. Also, without the defendant's affirmative act of creating the danger by putting me and my attacker together in that room, the attack never would have happened. The defendants created the danger, and in the case of Jane Doe, it supports my argument because in that case, the court specifically said that the attacker did not appear to require strict security.
Mr. Olin, excuse me. Mr. Olin, excuse me. This is Judge McDonough. I want to ask you a question, if that's okay. The man that attacked you, do you have any information as to what he was committed for, why he was incarcerated?
No, I never got any of the information except that he was mentally ill.
All right. The Commonwealth's brief seems to suggest that he was civilly committed, but they also argue that other people at Bridgewater, you can be civilly committed and be criminally convicted. So do you know whether he was criminally convicted as well, or was he civilly committed, or do you just not know?
No, they would have not provided me with that information.
All right. And you were attacked in for lack of a better word, the cafeteria area, correct?
Yes.
So you weren't housed with this individual, correct?
No.
All right. Thank you.
Mr. Olin, this is Judge Sachs. I have a question. Do you argue that you should not have been sent to Bridgewater as a cadre or a worker because you had to be classified as minimum security?
I'm saying that even though it was like I was there to work, I'm saying that the way that the security was with the interactions with the if like I said, I don't know if he was civilly committed or if he was just a regular inmate there, but the way they had us interacting with each other, that's what I'm trying to. Can you repeat the question one more time, please?
Well, I'm asking whether you argue that you should never have been sent to Bridgewater State Hospital to work there because of your classification level.
Yes, I did mention that in one of the briefs.
And do you continue to argue that you were improperly placed at Bridgewater?
Yes.
And why is that exactly?
Well, there was one of the general laws that was stating that because I had a loss of life, and due to the fact that I still wasn't minimum eligible at that time, I shouldn't have been allowed to go over there.
I'm sorry, I didn't catch the phrase. Minimum what?
I wasn't minimum eligible.
Minimum eligible.
Yeah. At that time.
Minimum eligible security classification, or?
Yes.
I see. And what is your classification? Or what was it at the time?
at the time was to remain at a medium facility behind the wall, which Bridgewater was, but to get there, like you had to be like a minimum status.
Okay. Other than placing you at Bridgewater, where the man who attacked you was also placed, what other negligence do you claim was committed by the defendants?
Again, Your Honor, I don't have any of my filings with me, so I can't really go through them because I haven't had no access to the law library. None of my paperwork is in front of me, so I can't really point them out to you right now.
Okay. I'll ask another question. I understand you may not be able to answer it, but did you submit any evidence of explicit or specific assurances of safety that that personnel at Bridgewater State gave you when you arrived there? I know that you alleged that in your complaint, but do you have any evidence of that other than what's in your complaint?
Can you repeat the question again, please?
Yes. In your complaint, you claimed that when you came to Bridgewater, you were told that you couldn't lay your hands on any of the people who were civilly committed and that you needed to rely on correction officers and other staff to protect you if you were attacked. Other than what you claimed in your complaint, did you submit any evidence to the court below that would support that?
No. When I first got there, I did sign a paper saying that I was present there and all that stuff. But when I asked for that evidence to be presented from my discovery, it was never provided.
And this is a paper saying what?
It was just like that I received the manual books that I received, like in every institution that we go into when we first get there, we always signed stating that we did receive the manual.
Mr. Olin, this is Judge McDonough. I'd like to ask a follow-up question. As I understand it, this attack was very sudden. Is that correct?
Yes.
Did he come up? I understand he came up from behind you. Is that right?
Yes.
And also that you had no prior history with this man at all. You didn't even know him, did you?
Nope.
All right. So this was one incident, correct?
Yes.
All right. Thank you.
I think you also alleged, Mr. Olan, in your complaint that the defendants delayed intervening in the attack. Is there, and why do you say that they delayed? Why do you claim that they delayed?
Because while I was on the ground being attacked by the attacker, they stood around standing there. They just stood there, and I get several times gave direct order to stop, and after several more seconds, then they decided to intervene.
Were they waiting for enough correctional officers to arrive so that they could handle the situation more safely?
According to the video, it seemed like there was plenty because they were just surrounded and just standing there. So, depending how many other correctional officers were needed.
Mr. Olin, I just thought of another question I'd like to ask. Given that this attack was, there was no warning, it was very sudden, he came up behind you, there was no prior history, exactly how do you think the officers could have prevented it? I know you say they were slow to react, but you also say that you were promised that you'd be protected. How, given it was so sudden, how could they have prevented this attack?
Well, prisons are dangerous, but the defendants created a tinderbox at Bridgewater, and the fact, knowing that Bridgewater is where civilly mentally ill prisoners pose a irrational threat that exceeds the bounds of expected in the prison setting, they already know what type of environment is. So it's like, like if they're expected to act one way and to respond on another, and knowing that they have casualty workers here that ain't in the same mentality as them, they should have been in high alert at all times. And
So it sounds to me, Mr. Olin, what you're stressing the argument that you've made in your briefing today that you shouldn't have been in the same facility. Is that correct?
yes.
All right. Okay.
Well, Mr. Olin, I'm not seeing further questions from the panel. So is there anything that you'd like to say in conclusion?
Oh, no, I just like to thank each and one of you for this honorable time to listen to my argument and to answer the questions you got, each honor had. Thank you.
All right. Thank you, Mr. Olin. Ms. Sawyer.
Good morning, Your Honors. The case, I think, if I could respond to some of the issues brought up earlier. I'm sorry. If I could respond to some of the questions that were asked, Mr. Olin. There is no statutory prohibition from Bridgewater housing inmates who are sentenced and committed to Bridgewater, or inmates who are sentenced and classified to Bridgewater, or patients who are civilly committed who have come through the criminal justice system. As a matter of fact, Chapter 123, Section 18A, clearly contemplates having sentenced inmates at Bridgewater. It would be that subsection of the population which is also mentally ill and requires, that they need to be committed to the hospital, and that they're not appropriate to be housed in a penal setting. So clearly, that would suggest that the legislature contemplated commingling of populations. The Devlin case did, in fact, prohibit inmates from being housed and treated with civilly committed inmates, presumably with the idea to protect those inmates, those civilly committed people who were not part of a criminal background. There was also some legislation regarding the Massachusetts Treatment Center, where there was a requirement for inmates, sentenced inmates, to be kept separate and apart from those inmates civilly committed. And again, the rationale was to protect those individuals who were civilly committed from a criminal population. There was no prohibition regarding Bridgewater, and our position is that had the legislature intended for there to be a prohibition on that, it would have been articulated in one or more of the statutes.
Ms. Sawyer, may I ask, on what basis was Mr. Olin at Bridgewater?
He actually volunteered to be part of the workforce and was subsequently classified to Bridgewater State Hospital as a medium security Department of Correction facility. And
I think I saw a reference to a regulation, 103 CMR 453.08, that says that one needs to be classified as minimum security in order to be a worker at place like Bridgewater?
No, that's a misconception. That policy regulates the classification of inmates to minimum security facilities. And I think Mr. Olin correctly pointed out that medium and maximum security prisons have a higher security level. Minimum security facilities often don't have a physical structure which provides security, and so there's a more rigorous vetting to have individuals step down to a minimum security facility to be part of the workforce there. That doesn't apply to Bridgewater, which is a medium security facility, and as a result, that vetting process did not need to occur.
Okay, thank you.
Ms. Sawyer, this is Judge McDonough. I think I saw in your brief, if I'm wrong, I'm hoping you'll be able to correct me, that the man who attacked Mr. Olin was civilly committed. Is that correct?
To the best of my recollection, that's correct.
Go ahead.
I don't know the answer to that. If I could perhaps submit a 16L letter.
All right. If I could just follow up, and I know you're not able to answer me now, but do you know whether he was also committed as someone who'd been criminally convicted?
I think it's the same question. Yes, you're right. He could have been civilly committed as well as convicted. Okay. That's right. Correct. And I'd be happy to submit that later.
Thank you. And Mr. Olin is suggesting throughout his brief that this person was someone who was a person that the corrections officials could expect to be dangerous. Do you want to respond to that, or are you able to respond to that?
I did not see any particular concerns about this particular inmate. My sense was that Mr. Olin argued that the civil commitment population generally was dangerous.
Okay, and one more, if I may. Mr. Olin says that he's rather specific about it, that he was told that he could not lay hands on any civilly committed person, no matter, I think it was unequivocal, no matter what, and that the officers would protect him against such people. Why is that not specific enough?
We, as part of our orientation process, explained to inmates that we discourage fighting and that if there's an altercation, officers will respond. That's, I think, Mr. Olin in his argument earlier indicated that he did have a piece of paper signing that he received his orientation material. It would have been, presumably, it would have been included in that. Those assurances are not specific enough because they were not specific to Mr. Olin in a particular situation. Those were general instructions given to all inmate workers, and it reflects the department's interest in discouraging violence between inmates or inmates and civilly committed individuals in any facility.
If I may follow up, but we have to accept at this stage of the pleadings the truth of what he alleges, and he alleges something more specific than what you just described. In other words, he said he was told by particular officers, you can't lay a hand on him, as opposed to you saying, well, we discourage fighting, which of course you would do. He says he was specifically told, you cannot lay a hand on anybody. You need to rely on us to, well, I'm paraphrasing, obviously, we'll protect you. Now, again, if this case had gone to trial, I'm sure you would have witnesses that would dispute that. But at this stage, we have to accept the truth of what he says. So assuming what he said is true, why isn't that specific enough? You can't lay your hands on anybody for any reason.
Well, if I think actually in the big picture, it's not relevant because by his own pleadings, he actually didn't rely on any assurances because, according to his description, he was knocked unconscious at the onset of the assault. And therefore, he didn't rely on any assurances that may have been given to him.
Why wouldn't that be something for the jury to sort out?
I think it's a question of fact. It's in the pleadings. Well, that's not...
Questions of fact are for the jury.
That's the claim that Mr. Olin made, that he was knocked unconscious.
But didn't he also, this is Judge Sachs, didn't he also allege that he regained consciousness during the attack and even then held off on defending himself because of the instructions he'd previously received that he was not to lay his hands on any civilly committed person?
I don't recall that in the pleadings, no. I'm sorry, my recollection was that he indicated that he fell to the floor and was unconscious, and the officers eventually responded, and he was taken to the infirmary.
I'm assuming that the pleadings say enough about reliance. What is your position on the specific assurance then? Because I think in response to Judge McDonough's question, you said we don't need to reach that. Let's say we disagree with you on reliance. What do you say as to the specific assurance? Why wasn't this specific enough?
Because it didn't articulate a definite, clear, it wasn't definite, it wasn't fixed, it wasn't free from ambiguity, it didn't relate to a particular situation or a particular enemy situation that he made known. It was a general assurance.
And what's your best case for the proposition that this kind of, while you're under our employment, we generally will protect you, is insufficient?
Are you looking for a case to support what I'm saying?
Exactly.
I'm sorry. I think it was very well articulated in the Lawrence case.
Okay.
And okay, thank you.
Let me jump in there if I can, counsel, on the Lawrence case. You do a good job of distinguishing Lawrence. So that's, I'll say that. But on that question, and I'm quoting from Lawrence, and as follows: we hold that the plaintiff's affidavit is sufficient to raise a genuine issue of material fact as to whether the city's promise was explicit and specific. In other words, as I read that, they weren't saying that it necessarily was specific or explicit enough, but that it would be up to the jury when they say to raise a genuine issue of material fact. And so, again, it's distinguishable, certainly, but what the point I'm trying to make is that Lawrence seems to stand for the proposition that whether or not it's specific or explicit enough, you only have to raise a material fact, an issue of material fact, and then it's up to the jury to decide. And so, why does that part of Lawrence not help Mr. Olin's case?
Again, I am back to the situation where he didn't have an opportunity at the onset to actually rely on those assurances. And I'm sorry, assuming that assurances were made, Mr. Olin doesn't allege that he would be protected at a particular time and place, whereas in the Lawrence case, that's exactly the situation. I believe a police officer that a witness was advised that police officers would be available to protect him when he closed up his shop at night. There's nothing approaching that in the pleadings to suggest that any assurances were made that were specific and grounded in facts or concerns that Mr. OLAN had relayed.
And what in your mind is the difference between saying you're going to be protected when you close the shop at night versus you're going to be protected while you're employed in this location?
Your Honor,
Ms. Sawyer, just before you
sorry.
answer, I want to let you know you got 45 seconds left.
I am sorry, for some reason your voice did not come through. Could you ask that question again? I apologize.
I sure can, which is, the question was, what is the difference in your view between assuring somebody that they will be safe at night when they close the shop versus assuring somebody you'll be safe while you're employed at the hospital?
I don't know that an assurance was made, nor do I believe he claimed that an assurance was made that specifically that he would be safe. I believe his claim is that officers would protect him if he were attacked.
Yeah, so I misspoke. So what is the difference between you'll be protected when you leave the shop at night versus you'll be protected while you're employed at the hospital?
Because the assurances given in the Lawrence case were specific as to time and place and protection for a specific threat. And we don't have that in this case.
All right, your time is up, so we'll have to leave it there. Thank you both, Mr. OLAN and Ms. Sawyer, for your arguments, and we hope you both stay safe.
Thank you, Your Honors.
Thank you, Your Honor.
Thank you. So,
All right, we are live and on the record.
good morning and welcome to the Massachusetts Appeals Court oral argument session. Our next case is number 2019 P918, Commonwealth versus Carlos M. CRUZ. My name is Justice Peter Sachs, and with me are Justices Dalila Wendlandt and Edward McDonough Jr. Appellant's counsel, can you please state your name and the party you represent?
Good morning, Your Honors. Josh Daniels for Carlos CRUZ.
And appellee?
Good morning, Catherine Sherman for the Commonwealth.
As you know, this argument is being held on Zoom and live streamed to the Appeals Court's YouTube page. Anything said will be heard by all those observing and become part of the record, just as in the physical courtroom. A pseudonym must be used for any person's name that's impounded, and impounded information must not be disclosed. Please speak slowly, clearly, and one at a time. You'll be on mute till it's time for you to argue. You'll each have 15 minutes. The session clerk will display a countdown. We've read your briefs, and the record. We know the facts, so we urge you to jump right into your argument. And with that, Mr. Daniels, why don't you begin?
Thank you, Your Honor. Good morning again. May it please the court. By way of a roadmap, I plan to start out with the sufficiency issue and then at some point move on to the constellation of other trial errors that I presented in the opening brief as issue number 2. For sufficiency, there are really only 3 things that the court needs to keep in mind about this case. Number 1 is that the girl testified that the breast touching occurred only on couch 1, and she specifically denied that it happened on couch 2. Second, the video conclusively proves, and the Commonwealth agrees, see page 28 of their brief, that no breast touching happened on couch 1. And number 3, the Commonwealth offered no evidence that breast touching occurred anywhere besides couch 1. Their brief doesn't even try to argue that the video alone proved that it happened on couch 2.
Well, why can't the jury believe the victim's statement that the breast touching occurred, while not believing her assertions that it occurred on couch 1 and not count 2, perhaps attributing that to her upset over the incident, her statements that the couches looked identical, her confusion in other parts of her testimony over certain things that occurred on couch 1 versus couch 2, like where the conversation about the ankle or foot was. Why couldn't the jury take her allegation about the touching and believe that, and essentially separate that and disbelieve her argument about where it occurred?
Because, Your Honor, our position is that that would distort the testimony. And for that, we rely on Zanetti and the recent Lopez case that came out in March. And what you've stated is essentially the Commonwealth's position. I don't think the Commonwealth has offered any meaningful way to distinguish Zanetti. They didn't have a chance to distinguish Lopez yet. But what those cases basically teach us is that when a witness testifies about an event and says it happened in a particular way, the jury can't then use that testimony and find actually it happened in some other way that contradicts what the witness said. And here there was contradiction. It's not just the location of the couch, it's also the sequence of events. She says that the breast touching preceded her moving to the other couch. It's also where they were both sitting. She's very clear in her testimony on page 130 of the record appendix that when the breast and the pubic area touching happened, Mr. CRUZ is seated down next to her on the same couch that she's sitting on. We see from the video that that never happens on couch 2. So it's not.
In what sense is that the part of her testimony about where the touching occurred integral to her testimony that it occurred? Because that's the word that's used in Zanetti and some other cases, that it's got to be, the jury could disregard it unless it's integral to her testimony.
So I think it's integral because it's not simply about where, it's also about how, and the sequence of events and the entire context of the episode that she's describing. I think it's also key to emphasize that, disbelief of testimony is not competent evidence of anything. It just means we don't know and we have to look elsewhere. And so, the jury can disbelieve her based on the video alone when she says this happened on couch 1, but that doesn't supply evidence going the other way. The Gonzalez case is pretty clear about that. And the basic problem here.
So we don't need evidence as to where it occurred or even the precise sequence. We just need evidence sufficient to establish that the touching did occur. And here she testified that it did occur. So why is that not sufficient?
She testified that it occurred while he was sitting next to her on couch 1. And I don't think Zanetti really allows you to port that over to couch 2. I see this as, I hear this argument, and my perspective is you could have made a very similar argument. One could have made a very similar argument in Zanetti or in Lopez. In Lopez, the discrepancy is about whether this took place in the driveway or in the backyard, among certain other things like what people were wearing. You could have just as easily said about the girlfriend in that case, well, she must have been confused. Probably it took place in the backyard and she's just getting the location mixed up. But she very clearly saw the defendant participating in the stabbing. And what the SJC said was, no, that would distort what she actually said. And when the testimony is very clear about the sequence of events and how this happened, and the Commonwealth wants to go beyond that testimony, or not even just beyond, but say something happened a different way, when the theory of the crime departs from the testimony, what they need is other evidence that supports their theory of the crime. And here I suggest they didn't offer that. Again, they don't say that the video alone would suffice.
Mr. Daniels, if I can jump in there, please, just for a moment. Isn't it undisputed that there was a period of time when the two were together that is not on video?
They're in the lobby together, and the video camera doesn't capture the entirety of their presence in the same room. There's a limited field of view. And
the reason I ask, excuse me, is that you cite us to the case law that says, for example, if there's an interview of a defendant on tape, then we don't have to defer. We can just look at the tape and decide for ourselves. But it jumped out at me that there was, and I think you're agreeing with me. If I'm wrong, let me know, that there was a period of time where they were together and they were not on video, correct?
Correct. The video does not capture the entire interaction. I think we all agree about that.
Okay.
The problem is we're beyond what the video shows us, and we're very much outside the testimony of what the girl said happened. And, you know, without anything underneath us, I think we're just guessing about what happened off camera is basically my position there.
Well, let me ask you this. What if the testimony had been that there was only one couch and no video, and the victim repeatedly testified that the couch on which the defendant assaulted me was red, not green, but there was some kind of irrefutable documentary proof that the couch was actually green? So could the jury believe that the assault occurred while concluding that the victim must be mistaken about the color? Or is the color of the couch somehow integral to her testimony, so that once the color, her testimony about the color is conclusively shown to be wrong, the jury can't believe anything else she says?
I think the color of the couch is not integral. I think, you know, which couch we're talking about and the relative location of the two people during this episode is integral. I think Zanetti probably demonstrates that best.
What makes it integral? Could not a rational jury conclude, based not on speculation, but on the victim's demeanor, on the fact that she says herself the couches look almost identical, that we see some things happening on couch 2, like the touching of the ankle that she at one point said occurred on couch 1. Why couldn't a rational jury conclude that she's simply mixed up about which couch the assault occurred upon?
So taking the ankle episode, I deal with that in my reply brief, and I really do think that's a different example, because with respect to the conversation about the ankle, we can actually see that happening on the video. So we don't have to rely on her testimony about where that happened. We have an independent basis for making that finding. I think the problem here is the girl unequivocally said this did not happen on couch 2. So we don't have the benefit of her testimony. In fact, it's contradictory to her testimony, and we don't have the video that lets us see for ourselves. So what we're basically left with is the Commonwealth introduced testimony that it happened on couch 1 and only couch 1. The other evidence the Commonwealth introduced conclusively refutes that. And we're left with no evidence that it happened anywhere, because she denied that it happened on couch 2. And you know, one other point I'd like to make about you know, what might or might not have happened off camera. It's important to keep in mind that as the court's case law has held, I'm thinking of the other CRUZ case, no relation, from 2018. You know, not every inappropriate or boundary crossing touching by an older gentleman on a young girl amounts to indecent A and B. It very much matters what was touched and how it was touched, and you just can't see that on the tape. And essentially, I think the Commonwealth is asking us to, and ask the jury below to, you know, speculate about it without the benefit of anyone who testified to this happening. I'd like to move on, if there are no other questions on this issue, to the other trial errors. And there's a lot here, likely too much for me to cover in my remaining time, but a couple of things to emphasize. One, we all agree that this is a substantial risk analysis. Reading the Commonwealth's brief, they don't appear to have any good response really under the first complaint doctrine to the evidentiary errors. They actually try to run away from that doctrine altogether, and our reply brief explains why that's wrong. And the Commonwealth's position that the closing was proper just doesn't hold up given the transcript, particularly when it comes to the vouching and the appeals to sympathy. The closing we suggest here was at least as egregious as the ones that were rebuked in Beaudry, Ramos, and Durgo. I particularly emphasize, the repeated references to how this was one of the most traumatic days of her life, that the detail she was required to relate was intimate and vivid, and the repeated emphasis on how it brought her to tears, and the exhortation to not to forget her because she's the reason we're here today. And almost exactly the same language as Beaudry, this last reference, which is she had nothing to gain by going through the court process and being on that stand, and that doing so made her emotional. It's essentially an argument. It's not some nuanced point about demeanor informing credibility, as the Commonwealth tries to suggest. It's exactly the kind of argument that the courts have said you're not supposed to make, which is you should believe this witness because she testified and that was really hard for her to do. I don't think there's any credible suggestion from the Commonwealth about some considered trial strategy that any of this was a part of, rather than simple oversight. It seems to me that everyone was on the same page in the morning of the first day of trial that this is how we'll handle first complaint evidence, and then the first complaint witness didn't testify, and everyone just seemed to forget that first complaint can still be an issue even when there's no first complaint witness, because the need for a first complaint witness is actually part of the first complaint doctrine. So I really think the issue here comes down to that third prong of substantial risk analysis, which is, in a nutshell, did this matter? Is it plausible that these errors combined made a difference in the outcome? And we think the answer is yes. The Commonwealth's case here was far from overwhelming. It rested solely on one eyewitness, the alleged victim, and her claim that Mr. CRUZ groped her breast. And nothing else corroborated that central claim. The video doesn't show the actual groping. There were no other eyewitnesses. The other witnesses who testified were not recipient. The hospital exam found nothing. And the video, as we've already been discussing, belied the girl's story of how this actually happened. And the acquittal on the vaginal touching, I think, suggests that her credibility presented at least a close question for the jury, because it's very clear that the jury did not believe everything that she claimed about how Mr. CRUZ touched her. The combined effect of all the errors, the first complaint evidence, or the multiple complaint evidence, and the closing argument was to improperly bolster the girl's credibility and make up for these deficiencies. And while there were no objections, I think this case is a lot like Montero in that there were numerous serious errors that infected the trial basically from beginning to end. And unless there are any other questions, I'll ask that you reverse and rest on my brief.
I would, go ahead, Justice Wendlandt.
I'm wondering, it wasn't clear from my brief if you were raising an ineffective assistance claim.
So I think there's really no difference here between ineffective assistance of counsel and substantial risk of a miscarriage of justice, because all the claims of ineffectiveness are effectively, pardon the pun, that counsel failed to preserve errors for appeal, and under Randolph, the analysis essentially collapses into substantial risk.
I wanted to ask one more question about the first, about sufficiency. Can you suggest to us any general definition of how we determine whether a certain part of testimony was integral to the rest? What test should we use?
So I think the location, I have not, in all frankness, come up with an intensive definition or an intrinsic definition of what is integral. I think the way I've been looking at it is, we know from Zanetti and Lopez that the location and the relative position of the actors is an integral part, because that's what was going on in those cases. And so if that's the difference the Commonwealth wants to rely on here, it's not enough to distinguish those cases. Like that's a guidepost that Zanetti and Lopez have already given us, and I think we have to follow here.
All right. Thank you, Mr. Daniels. Ms. Sherman.
Good morning, and may it please the court, Catherine Sherman on behalf of the Commonwealth, asking this court to affirm the defendant's convictions for 4 reasons. There was sufficient evidence presented for all convictions. Any hearsay testimony presented by the victim or put into evidence otherwise was insignificant to the jury and inconsequential to their verdicts. There was no error in the closing argument, and defense counsel was not ineffective. Beginning with the sufficiency of the evidence, as your honors seem aware and have addressed, the video in this case, or the mistake by the victim as to which couch she was sitting on when the indecent assault and battery occurred, is not at all integral to the charges or the elements. The victim in this case presented or testified to all elements of the crimes. She testified to her age. She testified to the groping of her breasts and her vagina.
So I think what your brother is suggesting is that it's not just the location of where the crime occurred, but the way that the victim described the touching and in the sequence of events, I think is how he put it. Can you address that? Why is that not integral to her story?
If your honor has, or if the court has had the opportunity to review the video and compare that to the victim's testimony, as I believe you all have, the video does not disprove anything about the sequence of events she testifies to. It shows where she's mistaken in the timeline of when absolutely inconsequential things happen, such as the conversation about the injury to her ankle, where she's sitting before he leaves the lobby when he comes back into the lobby. But nothing in that series of events and nothing in the video diminishes the sufficiency of the evidence about the indecent assault and battery and the enticement that occurred. She is mistaken about whether or not they were sitting on the same couch when the indecent assault and battery occurred. However, the video shows the physical opportunity for the defendant to commit that assault. It shows movements that are consistent with the assault described by the victim. And there truly is no mistake or inconsistency that's consequential to what the jury needed to find and decide when returning these verdicts.
Can you offer us any definition or test for determining what part of testimony is integral?
Well, I think inherent in Zanetti, I think there's a good framework for that. I can't offer a definition of my own, but the witness statement in Zanetti that needed to be accepted was definitively disproven by other facts and evidence. And this case is very unlike Zanetti in a number of ways, but specifically that for the jury to reach the verdict that it did, the joint venture theory of guilt, it fundamentally had to accept the disproven statement by a witness about where cars were positioned at the time that the victim was shot. That was an essential fact they had to accept to find that theory of guilt. What I think is important in Zanetti is that the court finds that that verdict was incorrect. However, the evidence presented at trial could have was sufficient to find the defendant guilty of a principal actor theory of guilt.
I wasn't sure why that's material. I mean, the issue in Zanetti was whether the joint venture verdict could be upheld. And they said, no, it couldn't because there wasn't sufficient evidence that the man in the front passenger seat had shot the victim.
Yes.
Why does it matter that there was sufficient evidence to conclude that the defendant sitting in the back right passenger seat could have shot him, and therefore it had to go back for a retrial? How does that help us determine what's integral or what the jury can and can't disbelieve?
Yes, perhaps that aspect of the case isn't getting to the answer that you were looking for about the definition of integral. However, I think it was important in terms of assessing the other corroborating evidence in the case that was properly presented for sufficiency on another theory of the case. And in this video, in our case, in CRUZ, the location of the couch is not integral because it speaks to no elements of the crime or any aspect of the presentation of the evidence that takes away from the victim's testimony. Your Honor, as you posed that question about the color of the couch, whether or not that would matter, I think that speaks well to why it's inconsequential. It's a fact that she was mistaken about. However, that fact has no bearing on whether or not she was indecently assaulted or enticed. And the video here really supports her, and it cuts both ways. And the defendant's theory of the case was that this sexual assault never happened, and they relied on the video for saying that. The theory of the case was that the video exonerated the defendant, but clearly the jury found otherwise. And I would suggest to the court that when you watch the video, it certainly doesn't dispel any of the sequence of events or the facts that the victim presented to the court.
I wanted to go ahead.
I'm sorry. Excuse me, Ms. Sherman, on the evidence of the indecent assault in the form of the kiss,
yes.
Counsel says that the case law requires evidence of the interior of the mouth being involved, and there was no evidence in that. So do you agree, A, that the case law does require that for a kiss to be indecent, it would have to be the interior of the mouth? And secondly, if that's correct, what's the evidence that the interior of the mouth was involved?
So Your Honor, I'm not familiar with the details of that, but in this case, the kiss was brought to trial under the attempt to commit a crime charge, which was directed out after the Commonwealth's close of evidence. The two theories of indecent assault and battery that were presented to the jury was the fondling of the breasts and the touching of the vagina.
All right.
I wanted to ask about the first complaint issues. Your primary answer to the claim on that seems to be that the extra complaint evidence was merely cumulative. But the King case, the Stuckich case, and the Montero case all seem to recognize that the repetition of a sexual assault victim's complaints may be especially prejudicial and may unfairly enhance the victim's credibility. That's why King said, from now on, we're only going to have one first complaint witness. We don't want piling on. Stuckich said, repetition of the narrative tends to enhance the credibility of the complainant to the prejudice of the defendant. And in a case where the credibility of the victim here was absolutely key, how can we conclude that getting 3 additional versions of her complaint in, that is what she told her mother in the lobby, what she told her in the ambulance, and what she said to the medical personnel that was in the records, how can we conclude, how can we have confidence that those didn't influence the verdict?
Sure. From the start, I'd like to say that this hearsay evidence, the Commonwealth's theory is that this doesn't fall under first complaint analysis because hearsay does not become a first complaint until a first complaint witness testifies. This evidence is simply hearsay, so we have analyzed it in that way. The cases that talk about piling on and repetition, as you've mentioned, are about multiple first complaint witnesses and the effect that they have on the jury when repeating the victim's statements about sexual assault. In this case, the victim's subsequent statements about the sexual assault, and by that I mean after she presented to the jury a detailed emotional, or a detailed, fully discussed sequence of events about the sexual assault, it's repeated in a very watered down version the hearsay of what she told her mother about the sexual assault. It boils down to about 4 sentences in broad terms about what she told her mother. As far as the medical records go, the repetition of what had happened to her at the hands of the defendant is actually admissible as statements for the treatment of statements for the purpose of treatment and diagnosis. The Commonwealth recognizes that the mother's recitation of the narrative is hearsay and should not have been included in those medical records. But again, it's a merely bare bones version of what the victim had already told the jury.
But isn't that the point? The point is that now the jury has heard 3 additional times what happened to the victim. And under King, I thought the whole point was you don't pile on. So whether you think of this as hearsay or whether you think of this as first complaint, either way, you've got the same story being told 4 times.
So, and respectfully, I think the story is told once and the bare bones of it are repeated twice. The instances of what she's told her mother and what the mother tells the medical providers are sparse in detail. They are simply that the assault happened, basically, in the most general terms. Importantly, with the medical records, those redactions were assented to by defense counsel. And I think that ascension to them also speaks to the fact that they were inconsequential and not very weighty when it came to the assessment of the credibility of the victim. In fact, part of the defendant's theory and line of defense was that she had perhaps been repeating and exaggerating the claims in response to her mother's emotional response to what she saw in the lobby. But taking the victim's testimony and demeanor on the stand, which was obviously very important, the credibility of the victim was incredibly important. The admissible version of events that came to the jury, the proper non-hearsay version, was the impact on the jury. That was what their verdict was based on, not these abbreviated recitations of what had happened in the lobby.
Counsel, if I may,
Yes.
the description of the assault in the medical records that came in, are you contending that that was independently admissible as an exception to the hearsay rule as medical records? And if so, what did that level of description have to do with how she was treated? That's generally the rule, that if it's information recorded to assist the medical providers, but it seemed to be a lot more than what we needed for treatment. Are you saying it's independently admissible?
A portion of it is, yes. On page 43 of my brief, I include what I believe would be independently admissible as statements for the purpose of treatment and diagnosis. And what would fall under that is that an older man approached her, grabbed her breast and vaginal area over her clothes. He then grabbed her chin and pulled her in to kiss her.
That's necessary for treatment?
Yes. Yes, for a medical provider examining a child, they need to know what parts of her body have been touched by whom and the circumstances of it. Yes. And that would be true for any sexual assault victim, that they would need to know the details of where and how they were touched to treat and diagnose them.
Why were the medical records relevant?
These were relevant in terms of the sequence of events that happen. In the video, it's clear that an ambulance and medical care comes to the victim, and it simply just told the complete story of what had happened to the victim that day.
That sounds like corroboration of the sexual assault and nothing more.
No corroboration of the sexual assault. It was the sequence of events that what had happened to her. The medical records.
What's your best case law for the proposition that you need to tell the rest of the story? I mean, the medical records, because she was touched over the clothes, show nothing in terms of physical injury. So what's the best proposition? What's the best law that you have for the need to tell the rest of the story?
I'm sorry, Your Honor, I don't have it off the.
Through the medical records.
Sure. I don't have it off the top of my head, but I'd be happy to submit a 16L.
I wanted to ask, even if we accept your suggestion that we view this purely as a hearsay matter, the rule that a witness's prior consistent statement is ordinarily inadmissible, according to the Mass Guide to Evidence, is because the testimony, and I'm quoting now from a case called Commonwealth versus Kindell, 44 Mass Appeals Court 200 at 202-203. The testimony of a witness in court should not need and ought not to be pumped up by evidence that the witness said the same thing on some prior occasion. So even if we put all the first complaint cases to one side, isn't this a case where her testimony in court was being pumped up by the 3 repetitions of it? Her saying she told the mother in the lobby and in the ambulance, and then what appeared in the medical records. So even on a straight hearsay basis, wouldn't that be prejudicial? As the Mass Guide says, the admission of cumulative accounts of prior consistent statements may create a danger of improper bolstering.
The admission of the hearsay statements in this case, and I'd just like to emphasize that they were unobjected to and admitted without objection in all circumstances. These statements are not prejudicial to the defendant because they are the victim's own words, and they are simply and I feel like I'm repeating myself, so I apologize, but inconsequential in relation to her broader repetition. This is unlike other circumstances in terms of the words are coming from her. It's not another person repeating her hearsay, and the fact that it is a simplification of what the jury had already been told.
All right, your time's expired, so we'll have to leave it there. Thanks to both of you for your arguments, and please stay safe and well.
Thank you, you too.
All right, we are live and recording.
Good morning and welcome to the Massachusetts Appeals Court oral argument session. Our next case is number 2019 P444, Commonwealth versus Candace DALEY. My name is Justice Peter Sachs, and with me are Justices Dalila Wendlandt and Edward McDonough Jr. Appellant's counsel, could you please state your name and the party you represent?
Nicholas Hurston, representing Candace DALEY.
And appellee?
Good morning again. Actually, yes, good morning still, Your Honors. Richard Langweber from Middlesex County in the Commonwealth.
All right, as you know, this argument's being held on Zoom and live streamed to the Appeals Court's YouTube page. Anything said will be heard by all those observing and become part of the record, just as in a physical courtroom. A pseudonym must be used for any person's name that's impounded, and impounded information must not be disclosed. Please speak slowly, clearly, and one at a time. You'll be on mute till it's time for you to argue. Each side has 15 minutes, during which we'll ask questions. The session clerk will have a countdown clock displayed. We've read your briefs, we've read the record, we know the facts, so please jump right into your argument. And with that, Mr. Hurston, I'll ask you to begin.
Thank you, Your Honor. The arguments made aren't going to be differing much from really anything presented in the briefs here, but just to reiterate, taking it from CR 2784, I guess I'll start with just taking it case by case. Just simply to state that the testimony here regarding the alleged hot water scalding of Ms. DeEsso, that the testimony was just that Ms. DeEsso turned and saw that Candace DALEY was running away and dropping a cup at the time. But the testimony doesn't say that any witnesses or anybody saw Ms. DALEY pour the water intentionally or move in an intentional way to make the water strike Ms. DeEsso. Ms. DeEsso did testify that there were other inmates around, some sitting at the table with her, I believe, and I don't think there was a direct question as to other inmates within the vicinity around, except for maybe at another table. But just simply that seeing Miss Daly having a cup, which, as the testimony also pointed out, the inmates have access to water and would presumably thus also have access to cups. So if that water is hot and these cups are plastic, then maybe other.
You, Mr. Hurston, can you just clarify? You keep referring to a cup. I thought it was a melted peanut butter jar.
Yes, I'm sorry. Something being used as a cup vessel.
Yeah, isn't that important here in terms of the inferences that are allowable by the trier of fact, that there was a melting peanut butter jar, hot water just thrown at the victim, and then your client went away?
Yes, I believe you could take an inference in that direction. However, there was no testimony regarding what other inmates use for cups. Maybe that's a standard practice, but just simply that she did not see that cup was filled with water at the time. It might have been melted from having been used for hot water before, and that the testimony wasn't that an intentional act of throwing the water was seen, just simply that Daly was running and dropped the cup. So on that basis, we were arguing that because there was no evidence that somebody else witnessed her actually throwing the cup or throwing the water from the cup, or that it was an intentional throw or anything like that, that there was not sufficient evidence to convict that the motion for sufficient finding should have been allowed, or motion for insufficient. I'm sorry, I also practice in Virginia, so I'm getting some of the terms in my head that should be used down here versus there. Sorry about that.
I think we understand you.
Thank you. Just moving on to section 1649-804. This was the attempt of assault and battery by shod foot. The arguments here are twofold. One, that the apparent ability argument about the length of restraint that Miss Daly had, that it should have been apparent that Officer Rodriguez, knowing these restraints, knowing how far they can go, it should have been apparent that she could not have kicked him, because he knows how far those restraints go. And so that respect, it was not objectively menacing, because he would know how far she could have kicked in the first place.
But she came within a couple of millimeters, didn't she?
Yes, Your Honor, that is undisputed.
And so should the correctional officer be able to estimate a distance of a couple of millimeters in the heat of the moment like that?
Well, I would argue that yes, that Officer Rodriguez should have been able to recognize the distance. He's worked with these restraints before. He had recognized that the restraints were in some way broken or malfunctioning. But that, reasonably thinking, you would understand kind of how far away you were. And the thing is that he was correct in his estimation, because he was indeed far enough away.
Well, we don't know whether she missed because the restraint stopped her from going further, or because she didn't have good aim. Do we?
No, and it may not be either of those. It may be that she was also aware of the restraint or the length of the restraint, and whether or not she was intentionally kicking, if she intended the act to occur with knowledge that she couldn't have committed, that she couldn't complete it in the first place. So there is the aspect of it, whether or not it was intentional acts on her part.
restraints had 12 to 18 inches of movement. Is that?
I've never really understood why it would have 12 to 18 inches. It's a length of chain. I don't presume that they would use something she could stretch.
Okay, yeah, that was my question, is if the length itself is variable, then I don't know, the argument is somewhat moot, but I didn't understand that factually.
Right. I'm sorry, Anna. I'm not sure it was well described on the record.
You argued that on the immediately threatened battery theory of assault, that because Correctional Officer Rodriguez didn't testify, there's no evidence that she actually felt threatened. And I wanted to ask, is such evidence of the victim's subjective fear necessary, or is it only required that a reasonable person in her position could have felt threatened? And that the other correctional officer could testify as to that?
Well, Your Honor, I think that it does have to have a reasonable component as opposed to subjective, because somebody may have irrational fears that could play into a more subjective fear of something, whereas an objective person might recognize that the fear should not have existed.
But does there also need to be evidence of subjective fear, or is it sufficient that there's evidence that a reasonable person could have feared?
I don't think that there needs to be this subjective fear. No, Your Honor. And I say that in recognition of the case law that I'd seen to this point. But there needs to be there needs to be an apparent ability for it to which is more of an objective determination.
Thank you.
And then finally, just moving on to 2606. The testimony there showed that she was being cuffed, and then at some point her right arm is alleged to have raised in a way that Officer Flannery was alleging was an intentional act to try and strike him. I don't believe there's any testimony that it didn't strike him, so we can take as much that it did. But whether or not it was a voluntary act, or if perhaps she was even enacting an irrational fear herself at the time there. But she, our argument here is that the testimony was not sufficient to show that she voluntarily raised her arm in that way. And then further, once she was taken to the ground by multiple officers, at that point it becomes more of an objective threat to her, and that her self-defense felt rational and warranted at the time. As far as who was the first aggressor, I certainly understand the argument that the raising of the hand to Officer Flannery during the cuffing process could be considered the incitement, the first aggression. However, that would need to show that it was, a voluntary act, which I don't believe the testimony has necessarily shown. And then from that point, when she's taken to the ground with assistance, her actions then become more in the sense of defending herself from being mobbed. And for that, she should be granted a defense of self-defense. And the evidence was insufficient.
All right. Seeing no further questions from the panel. Unless you have anything further to say, Mr. Hurston, we'll hear from the Commonwealth.
Thank you, Your Honor. I would just like to, my apologies, Mr. Hurston. I would just like to address some of Mr. Hurston's points. To be quite candid, I think the court's already hit on many of the points I would like to make with the court's questions. First, with respect to docket 2784, that's the incident in the prison yard where Ms. Deosa is the victim and the hot water is tossed on her. As the court already noted, it wasn't simply that the defendant was holding a peanut butter jar. It was recently melted, according to the testimony, which would suggest that the water had recently been in there. In addition, the defendant, immediately upon the victim turning and viewing her, fled the scene. And that is further evidence of her participation in the crime. It's further evidence of her intent. I think even Mr. Hurston sort of acknowledged on his argument that the finder of fact could make the inference of her intent at that point, and viewing the evidence in light most favorable to the Commonwealth, as this court must, the conviction should be upheld. Unless your honors have any questions with respect to docket 2784, I'd like to move on to the next docket. Okay, thank you. With respect to this docket, I'd just like to address one question that came up about 12 to 18 inches worth of movement. And I'll sort of admit the record is a little bit sparse about this. My interpretation of that was that it was the officer's estimate. He estimated that it was anywhere between 12 and 18 inches worth of movement. He was not able to, it wasn't a range, it wasn't like a rubber band that could snap back and forth. I would also add that sort of to Mr. Hurston's point, that the officer would know how much range of movement there was simply no testimony on that fact. There was no testimony regarding the officer who was actually assaulted. He didn't testify, so there was no testimony with respect to his knowledge of the length of the restraints. And finally, as the court sort of alluded to, there's no evidence to suggest that she couldn't have completed this offense. The evidence is simply that she did not complete the battery. And as the court indicated, there could be a million different reasons why that battery was not completed. But the bottom line is she came within millimeters of striking him, and certainly a reasonable person in that situation, I think, would be in fear of a battery. So unless the court has further questions about docket ending 804, I'd like to turn to the final docket. Excellent, thank you. On the final docket, docket ending 2606, I just want to address the self-defense argument a little bit. It's not simply that she raised her hand to the officer before she was taken to the ground. According to the record, she actually punched the officer before she was taken to the ground. On top of that, the officer only approached her to put her in restraints because he observed the defendant becoming belligerent and combative in a room that contained approximately 20 civilians and approximately 20 other inmates and some unspecified number of other correctional officers. Under those circumstances where she was the first one to use physical force, where she initiated a confrontation by becoming combative and belligerent in a visiting room, she has no right of self-defense once she is taken to the ground. Unless the court has further questions or wants to hear on any further issues, the Commonwealth will rest on its argument and its brief.
Seeing no further questions, I want to thank you both for your arguments and hope that you both stay safe and well.
Same to your honor. Thank you.
Thank you, Your Honor.
All right, we are live and recording.
All right, good morning and welcome to the Massachusetts Appeals Court oral argument session. Our last case for the day is number 2019 P863, Anthony Berry versus Department of Correction and others. My name is Justice Peter Sachs, and I'll ask the other justices to introduce themselves, please.
Good morning. My name is Justice Edward McDonough.
Okay.
Good morning or good afternoon. This is Justice Dalila Wendlandt.
All right, and Mr. Berry, just for the record, could you state your name?
Anthony Berry.
All right, and Mr. Gordon, could you state your name and the parties you represent?
Good afternoon, Your Honors. Richard Gordon, counsel for the Department of Correction, here on behalf of the defendants.
Thank you. As you both know, this argument is being held on Zoom and live streamed to the Appeals Court's YouTube page. Anything said will be heard by all of those observing and become part of the record, just as in a physical courtroom. Please speak slowly, clearly, and one at a time. You'll be on mute until it's time for you to argue. Each side will have 15 minutes to argue, during which we'll ask questions I will, because you can't see the clock, try to give each party notice when there are only 90 seconds left in your argument, so you can try to wrap up. We have read your briefs and the record. We know the facts, so we would urge both of you to jump right into your argument. And with that, Mr. Berry, I'll ask you to begin.
Well, I'd like to say that since you received my brief, I was removed from my cell, and the contents. I have no access to any of my legal materials. So if I can, I would like to have the court rely on the brief and all of my basically that. I have nothing to use for my argument. I have no notes, nothing. It's all in another cell. I was removed and set from one cell to another, so I have no legal materials with me.
That's regrettable.
Yeah.
We may have some questions for you that you may be able to answer without the materials available.
I'll try my best.
Mr. Berry, this is Judge Wendlandt. I'm wondering, you raise an Eighth Amendment claim, and in particular with regard to your cellmate, I guess it was your then cellmate who had MRSA. I'm wondering, well, obviously that's no longer the situation. What is it that you would like from the court then? Is it not now moot that your exposure to MRSA at that particular time?
No, it's not moot. The circumstances still exist, not necessarily for me, but they will again, because any particular housing situation that I'm in currently is always subject to change. Just a few days ago, a week ago, they suddenly moved me to a COVID block. I'm in a block with people with COVID, whereas I wasn't before. And I don't know why. They haven't answered my questions yet. But so these things are they're fungible. They're always changing. I would like to make my situation permanent. Is basically the gist of this whole lawsuit.
This is Justice Sachs. To follow up on that question, your complaint said that you were cellmates with Mr. Ford for 6 months in 2018, and I wasn't actually sure whether that was 6 months and continuing at the time you filed your complaint, or whether he had already been moved to another cell, or you had been moved by the time the complaint was filed.
At the time I filed it, he was still with me.
And before the whole COVID thing arose, was either he or you moved to another cell?
Yes, that situation, but yes, this was back in during that time in 2019. My situation is obviously different now. Yes.
Okay.
But the policies that the Department of Correction uses for housing and cellmates remain the same.
Now, even if he's been moved and you've been moved, I suppose it's conceivable one could still seek damages under an Eighth Amendment claim. But absent any evidence that you actually contracted MRSA, are damages available under the Eighth Amendment for the emotional distress of worrying about getting sick if one doesn't actually get sick?
Yes, for sure. There's no the Eighth Amendment if I remember the case right, it's trying to remember. You don't actually have to suffer damage, suffer harm. It's not when you get sick. It's whether or not you are exposed to it, or there's a likelihood of harm.
That might well be true for purposes of seeking injunctive relief. For example, if he were still your cellmate and you wanted an order from the court that either he be moved or you be moved or additional hooks be put in the cell for towels. But where you and he are no longer in the same cell, it seems to me that the main question under the Eighth Amendment claim would be, could you recover damages? And so since you didn't get sick, that's why I'm asking whether damages for just emotional distress are available.
Well, I was put in the situation. I was placed there, and against my will, the Department of Correction was aware of it, the ongoing matter at the time, and ignored and refused to address it. So the answer is yes. They did place me in harm's way.
This is Judge Wendlandt again. How do we, you say that the Department of Correction did not address it, but you were moved, or Ford was moved out at some point. I'm wondering how do you square that statement with the Department of Correction didn't address it statement?
They refused my grievance. They refused to make any of the demands that I had put forth.
Can't they come up with a different solution than the one that you want? Right, the solution you wanted was, I think, to be housed in a single cell. Isn't an alternative solution to limit your exposure to?
Yes, in the brief, I mentioned also they could expand the cell sizes. They could add furnishings to make it doable for two people. More time out of the cell, which is also part of the 12 hours in, 12 hours out thing. Like I said, a lot of this is written somewhere else. I'm going by memory here.
I appreciate that. But one of the alternatives, it seems to me, is to separate you two, which it sounds like they did.
They did, but the conditions persist that the next person could, or I could contract MRSA and put someone else in danger. The situation, the procedures that they use still persist.
Although I'm sure this isn't in the record, Mr. Berry, do you know the reason why either Mr. Ford was moved out of the double bunked cell or you were moved?
He left the prison eventually, and someone else was moved in.
So at least before the COVID pandemic hit, you were still double celled, double bunked?
Personally, I was not. I am not.
Okay. Even before the pandemic?
And before yes, before. But like I stated before, this is not a permanent situation. You can go from one cell to another at any moment at their whim.
Sure.
Mr. Berry, this is Judge McDonough. I want to ask you about Judge Ullman's decision. I know you don't have your papers. Do you recall Judge Ullman's decision? Where he dismissed? Okay, I just want to ask you this. The department moved to dismiss your complaint. You then asked for additional time to respond to that motion to dismiss. Judge, that was granted to you, but you never filed, according to Judge Ullman, an opposition. Instead, you filed a motion to expand your lawsuit. So I'm just curious, why did you not file an opposition to the department's motion to dismiss your complaint?
The motion to dismiss was, there was no response to the, oh gosh. Let me see, hold on one moment. I do have a couple of notes. The defendants filed only a certified record, and they did not answer the civil rights claim. That was the issue.
Well, if that's true, Mr. Berry, no, forgive me for interrupting you, but if that's true, why didn't you say that in an opposition? According to Judge Ullman, you didn't file anything in opposition.
At that point, I didn't have to. It wasn't yet due.
Why do you say it wasn't due? You were granted an extension to respond to file an opposition, until April 5th, according to Judge Ullman. And then instead, after that date, or by that date, you still had not filed an opposition. Do you remember why?
Honestly, I don't have any of my records here with me. I filed that to expand the record, which what I thought was within my rights, because the defense hadn't yet filed an answer to the civil rights claim, which left me open to amend my complaint.
Would you agree that by filing the administrative record, they had at least answered the part of your complaint that was directed at getting a review of the denial of your grievance?
That would address the judicial review, but not the civil rights complaint.
Okay. So if we treated, or if the judge looked at the defendant's motion for judgment on the pleadings as a motion to dismiss your civil rights claim, understanding that you've never filed an opposition to that, still, do you see any legal errors in the way he analyzed and decided to dismiss your Eighth Amendment claim in particular?
At this point, I don't have a copy of the defendant's motion to dismiss, so there's no way I can respond to that question. I would have to defer to my brief.
Okay.
If that's okay.
Yes.
Barry, this is Judge Wendlandt again.
Okay.
In your complaint, you mention other diseases, not just Mr. Ford's MRSA. You mentioned scabies and others. Is there any basis that you have for that at all? I mean, it seems like the Ford allegations are based on being a cellmate with Mr. Ford, but the other diseases, is there anything to those?
Just experience from what I've seen that these things have been contracted between cellmates in the past. You see it all the time, and those are just what I had experienced. Okay. That is all, yeah. And now this currently what is going on is a whole nother story. I would have added this if I had foresight.
Well, Mr. Berry, we understand you're in a difficult position not having any of your papers with you. You do have 2.5 minutes remaining on your time. Is there more that you want to say directed to why we should reverse any part of the lower court's order dismissing the complaint?
I'll just reiterate that what is the gist of my argument would be just to refer to the brief. I'm really at a loss here, to be honest with you, and I'm not experienced in this either. So, yeah, if you could just refer to the brief.
Well, you're doing quite well, considering that you don't have your papers in front of you, and I assume haven't had them for some period of time.
Okay, well, thank you.
All right, well, seeing no further questions from the panel, why don't we then hear from Mr. Gordon for the defendants?
Thank you, Justice Sachs. Good afternoon, and may it please the court. Your Honors, this court should affirm the memorandum of decision that Judge Ullman entered below. There was ample evidence in the record that the case was subject to dismissal, and Mr. Berry should not have been permitted to amend his complaint. And in fact, it was not an abuse of discretion for Judge Ullman to deny that. Your Honor, this case...
This is Judge Wendlandt. Can I ask you to address the Eighth Amendment claim that Mr. Berry was being exposed to MRSA? Why is that dismissible at this stage?
Yes, Your Honor, and I would like to actually follow up with the point that you asked Mr. Berry during his argument. It is my understanding, and I looked into this today, that the cellmate who is alleged to have had MRSA Jamie Ford was paroled to the street in 2019. So it's my understanding. Unfortunately, it's not in the record because we're dealing with a Rule 12 motion, Your Honor. So certainly, any claim regarding injunctive relief would be moot, as Mr. Ford is no longer in custody, and certainly not confined with Mr. Berry. With respect to any sort of damages claim arising out of that, Your Honor, the operative case here is Farmer v. Brennan. Farmer v. Brennan is the Supreme Court case that declared that.
Red Farm. Why isn't the operative case the Heller case that Mr. Berry cites in his papers?
Heller was distinguishable, Your Honor, because it dealt with cigarette smoke, and it sort of stood for the unremarkable proposition that Farmer did, and that is that if a prison official is deliberately indifferent to a serious risk of substantial harm, that will state an Eighth Amendment claim, that an Eighth Amendment claim will lie in a situation such as that.
Why doesn't that rubric that you've just set forth fit exactly what Mr. Berry was experiencing when Mr. Ford was his cellmate?
Because, Your Honor, in order to meet the plausibility threshold for an Eighth Amendment claim for failure to protect under Farmer, an inmate must do more than show that theoretically he was exposed to some sort of harm. The harm must be imminent. The harm must be likely or very likely to occur. And that is certainly not the case here, where Mr. Berry did not, in fact, contract MRSA or any other communicable disease, as we know. And so on those facts, Your Honor, the court...
Mr. Gordon, is that the test for likely or to occur, that it must actually occur? Is that what Farmer stands for?
It does not. It does not. We don't have to sit around and wait for the harm to occur, certainly, Your Honor, and you're right. Farmer doesn't stand for the proposition that an inmate has to actually suffer harm, but the harm must be more than theoretical. It must be imminent or very likely to occur. And in this particular case,
in a cell with a prisoner who has active MRSA with pus drooling from his skin, you're saying that under Farmer that doesn't meet the Eighth Amendment, stating a claim even?
No, Your Honor. And in fact, I would point to the only evidence that we have in this record with respect to Mr. Ford is found on page 65 and 64 and 65 of the appendix that Mr. Berry filed, and that is a grievance that Mr. Ford filed to the Health Services Administrator with respect to his MRSA, and in August of 2018, the Health Services Administrator responded that he was being medically treated with antibiotics and didn't have active MRSA, and that's found on page 65 of Mr. Berry's appendix. And so we need to strip the complaint of the conclusory allegations that he was very likely to contract MRSA. And when you look at the records here, it shows that Mr. Berry, records that he attaches to his own proposed amended complaint, it shows that Mr. Ford was not, in fact, posing a threat of harm. And in further, Your Honor, the administrative record that we filed...
Can I just stop you right there, Mr. Gordon? This is Judge Sachs.
Yes.
So this was a motion for judgment on the pleadings, which is the equivalent of a motion to dismiss. I think you'd agree with that?
Yes, Your Honor.
Motion to dismiss for failure to state a claim. So putting aside the Mr. Ford's medical grievance, it seems to me there were some very specific allegations in the complaint, and I'm looking at Record Appendix 44 right now, about MRSA being fatal. MRSA is commonly spread by towels that have touched the infected skin. spread by touching surfaces that have been exposed to MRSA bacteria. It's serious and highly contagious. Very specific allegations that need to be treated as true at the motion to dismiss stage. So I don't understand why that didn't state an Eighth Amendment claim. Along with the allegations, of course, of deliberate indifference.
No one, Justice Sachs, is arguing that MRSA is a very serious medical condition or that it's very contagious. But the conclusory statement in the complaint is with respect to the fact that Mr. Berry asserted that he was likely to contract this.
Well, does he have to have expert evidence at the complaint stage, or can he say, my towel is touching or very close to the towel of someone who has an active case of this highly contagious disease, and I am at risk, I'm in fear that I'm going to catch it too? What more does he have to say in the complaint?
Certainly an expert opinion would be, I think, would be enough, Your Honor. I certainly don't think that an expert opinion would be required, but here just saying again that you're likely to contract the disease, well, if you take Mr. Berry's argument to his logical conclusion, it would mean that all inmates would have to be in single cells, right? Because theoretically, there's lots of inmates, any one of whom could have some sort of an infectious disease, and that's the argument, right? It would be that everyone would have to have a single cell, and the Supreme Court precedent that is cited in the brief is quite clear that there is no one man, one cell provision in the Constitution. Prison officials cannot be deliberately indifferent to a serious risk of substantial harm, and that's quite a high burden to overcome here. And Mr. Berry, I submit to the court, did not overcome that burden of showing plausibly that any one of the individual defendants was deliberately indifferent to a serious risk of substantial harm to him. And I'd also like to point out, Your Honor,
Mr. Gordon, why you're suggesting that these defendants were not deliberately indifferent to his plight, given that he reported his plight to them and essentially nothing was done. I think there's an allegation that he was laughed at. Can you explain that more specifically, get granular? Why is the not enough to state a claim that these defendants were deliberately indifferent?
Yes, Your Honor. Under the Ashcroft v. Iqbal case, as I'm sure the court's well aware, you have to, in order to survive a Rule 12 motion on a civil rights claim such as this, or a Bivens claim, you have to show that the individual defendant, by that individual person's own actions, caused a deprivation of constitutional rights. Here, with respect to the grievance coordinator, I think you were alluding to, Judge, we filed the administrative record, and the administrative record, with respect to the grievance, the hearing officer's notes stated that she contacted a health services administrator and asked whether or not there was any risk of MRSA befalling Mr. Berry, and that the answer from the medical clinician was in fact no. And so that is the reason why she denied his particular grievance. With respect to the other defendants,
can I back up on that? Just stop with that grievance coordinator.
Yep.
Why isn't it enough to state a claim? I mean, I feel like you're conflating our judicial review of the administrative action with regard to the grievance with the independent Eighth Amendment violation that he's asserted. That is, Ms. Walsh could come in and say, actually, I wasn't deliberately indifferent. I investigated, I was told, I actually took this quite seriously. I was not deliberately indifferent. Then that goes to discovery, right? And maybe at the end of the day, she gets out. But why is it not enough to state a claim?
Well, Your Honor, these cases, and I'll be perfectly honest with the court, these cases get very murky, and we at the Department of Correction have a lot of these types of cases where an inmate files a claim for judicial review of an agency proceeding, whether that be, I'm appealing a prison disciplinary report or I'm appealing a prison grievance decision. And along with that, there are pending civil rights claims.
And how do you usually deal with these then, given your expressive experience?
We routinely deal with these types of cases under the Crowell case, Your Honor, and it's cited, I think, in a footnote in the brief. We really don't file 12B6s for the most part right off the bat on a case like that, because there the SJC held that it was reversible error for the parole board to move to dismiss a certiorari claim without filing an administrative record. What the SJC wanted in that particular case was the administrative record filed. So that is why in a case like this, where there's a claim for judicial review under 127 section 38H with a pendant 1983 claim, file the administrative record so that the court can do its judicial review function of that agency decision, and then file a 12C motion seeking, affirmance of the grievance coordinator's decision under the judicial review statute, and then also dismissal of the civil rights claims. Obviously, those things are evaluated somewhat differently by the judge, right? So a claim for judicial review is going to be confined to the record, as opposed to the 1983 claim. We, on a Rule 12 motion, have to accept as true the factual allegations.
So perhaps on the review of the grievance denial, Ms. Walsh's call to Jen in the medical services unit, who says Mr. Berry's at no risk of MRSA, might constitute substantial evidence, perhaps, but in order to affirm the denial of the grievance. But the record isn't really closed on the Eighth Amendment claim. And for the Eighth Amendment, you need to take the plaintiff's allegations as true on the motion to dismiss or motion for judgment on the pleadings. So taking them as true, perhaps her statement that Mr. Berry's at no risk is not enough.
I agree with you, Justice Saxon, that it's obviously two separate analyses, unfortunately, and that, of course, I think you hit the hammer on the head, and that the court is performing two separate analyses at once. But I do not concede that even accepting as true everything, all of the well-pled factual allegations in Mr. Berry's complaint, that there was an Eighth Amendment claim there. I don't think he passes Farmer v. Brennan, which requires that he show deliberate indifference, which is a very high standard indeed. And I don't think that he passes the plausibility threshold. And I
Can I ask, since you don't have much time left, assuming for the sake of argument that his claim for injunctive relief were moot, could he get damages for the emotional distress of having lived in fear of contracting MRSA for some period of time, even though he didn't ultimately contract it?
Well, it's not something that's addressed in the papers, Your Honor. But I would suggest no, that under the Prison Litigation Reform Act, he could not get money for emotional damages unless there was actually a physical injury. There's a physical injury requirement under federal law, and it would be a federal 1983 claim that he would be asserting, albeit in state court. So I would not at all concede that, Your Honor.
All right, your time has expired, so we'll have to leave it there. We thank you both, Mr. Berry and Mr. Gordon, for your arguments today, and we hope you both stay safe and well. And that concludes our session for today.
Thank you, Your Honor.
Thank you.